Happy Monday, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about forcible confinement and first-degree murder. Cases that should have gone to the Supreme Court of Canada, but didn't. Following a verbal altercation outside a nightclub, a group of about 10 people swarmed an individual, pushed him down an alley and up against a dumpster, where he was ultimately stabbed to death by one man, Mr. Gervais. Mr. Gervais was convicted of first-degree murder, not on the basis of the stabbing itself, which would have amounted to second-degree murder in the circumstances, but instead on the basis of the fact that the victim in the case was forcibly confined. Under Canadian law, anytime forcible confinement is used that leads to a murder, the murder is presumed to be first-degree murder. This was the problem in the case, whether or not Mr. Gervais was responsible for the forcible confinement and whether or not Mr. Gervais was involved in the forcible confinement in a way that created a continuous transaction that led to his murder. And these were the important questions that the court was asked to resolve. Mr. Gervais was ultimately convicted of murder and his convictions were upheld, but the Supreme Court of Canada denied the opportunity to hear in order to ascertain whether or not the act of forcible confinement was something for which he was responsible, given that it was a mob mentality situation, and also whether or not it was part of a continuous transaction, or whether or not Mr. Gervais acted independently of the people who had essentially pinned the victim up against a dumpster in the alley and prevented other people from helping him. And this case raises important questions because if you have a legal provision that elevates one very serious charge to the most serious charge known in Canadian law, that provision needs to be subject to very strict and very clear interpretation by the courts. Because the greatest sentence that you can get for a crime in Canadian law comes from first-degree murder. The automatic life sentence with parole ineligibility for 25 years automatically, it needs to be clear in those circumstances who is guilty of first-degree murder and who is not, particularly where the other necessary elements of planning and deliberation are not in fact present in the circumstances. This was an opportunity for the Supreme Court of Canada to draw a very clear, very bright line about something that needs to be very clearly defined in order for people who are facing the greatest jeopardy in our justice system to know what to expect in their proceedings. It was unfortunate the Supreme Court of Canada didn't take the opportunity to clarify this because its decision could be used in all circumstances where an offense that leads to a murder is elevated automatically to first-degree murder. They had an opportunity to very clearly clarify provisions of the criminal code that are not that frequently used, but that do have significant consequences and are very difficult to litigate for all of the parties involved, including the Crown and the defense, and are difficult for judges to interpret and understand. Unfortunately, it'll take another case involving another murder in very unfortunate facts for the Supreme Court of Canada to have the opportunity to hear this, and we really shouldn't be hoping for that. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you for tuning into these videos. Please like, subscribe, and share with your friends.